Earlier today, I met with families from Newtown, Connecticut, to discuss legislation we're currently debating. And it's obviously very emotional, and it isn't an easy meeting to have, but it's a very necessary meeting to have when the parents of children that were murdered, or when I think somebody from a family that the teachers were murdered. It's difficult for everybody. I want to thank them for sharing their stories of loved ones and their concerns with me. And I hope many of my colleagues would consider meeting with these families as well, because, you know, when they hold up pictures of their loved ones, like each of them, I think each one of them had pictures of their loved ones. It makes it very personal what they've gone through. And here we're debating legislation that they're supporting. And in my state of Iowa, there's a lot of difference of opinion on that particular legislation that we might be considering. But I think it's something that's very worthwhile to sense firsthand the feelings of these meetings. At the meeting, they called for debate on the legislation. Right now, we're in the process of having debate, and I imagine we're going to be able to move forward on this legislation. And under new procedures available under Senate Resolution 15, the majority leader can move to proceed to a measure and to vote on some amendments. A vote against the motion to proceed does not cut off debate or vote on amendments under the new procedures in the United States Senate. Nonetheless, Madam President, we're in the unusual position of being asked to take a leap into the unknown. We're being asked to vote to proceed to an uncertain bill. That bill is not even the bill that we will likely consider if the motion to proceed is successful. The language on background checks would change, it's been my understanding. Remarkably, if the language changed, it would be replaced with language that does not now exist. And of course, the world's greatest deliberative body should not operate in this fashion. In the Judiciary Committee, 4 bills were considered separately. I think it's fair to say that there wasn't a consensus. 3 of them have now been combined, and they're not ready for consideration. At the time, the sponsor of the background check bill said that it was not ready. That's what he told us in committee. There were numerous problems with that bill, he told us. Movement of firearms from one law-abiding citizen to another would be legal or illegal based upon arbitrary distinctions that citizens could not be expected to know, putting people in maybe in an impossible situation. This is true even though when this language was the subject of a hearing in the previous Congress, a witness pointed out problems with it. But no changes have been made to address those issues. Even an official from the ACLU says that criminal laws should give more guidance to citizens. The bill operates in a way that would make gun safety efforts more difficult. That does not make any sense. The bill requires record keeping for private sales. This is a step towards gun registration. Indeed, we heard testimony in the Judiciary Committee that universal background checks cannot be effective without gun registration. And this ACLU official is right to be concerned about the threat to privacy that background check language presents. He notes that the government would possess information concerning gun owners that it would not be required to be destroyed within 24 hours, as it must be for current background checks. He also points out that the bill contains none of the restrictions in current law that prevent other parts of the government from using the database for purposes beyond why the information was supposedly obtained. The background check provision is also not ready for consideration because of the new federal felony that it creates. If a law-abiding gun owner's gun is lost or stolen, he or she would be required to report that to both the Attorney General and appropriate local authorities within 24 hours. At the markup, I asked a number of questions of the bill's sponsor about how the offense would work. For instance, who would pay for the additional law enforcement personnel who would take those calls? What would a citizen's legal obligation be if the gun were misplaced rather than lost? What would determine when the loss occurred that started the 24-hour period? 24-hour period in which the gun being stolen has to be reported. The sponsor said that these issues would be clarified. Well, so far, however, they have not been clarified. So law-abiding citizens will not know whether they are acting in compliance with the law, and if they aren't in compliance, they're going to face a five-year jail sentence. The issues have not been clarified, but we're asked to proceed to the bill anyway. This new offense, by the way, criminalizes inaction. That is a threat to freedom because except for filing tax returns or registering for the draft, we punish only bad actions. We do not punish inaction. This new crime punishes failure to act, and it only applies to those who lawfully own their guns. A criminal whose gun is stolen is not required to report that fact, that that gun in turn could still be stolen a second time. With this offense, law-abiding citizens can be turned into felons, but felons cannot commit a crime. Under this new offense, law-abiding citizens might be looking at 5 years in jail for what? For just doing nothing. And all that is necessary for the gun to be subject to a reporting requirement is that the gun once moved in interstate commerce. The Supreme Court has outlined these three categories of situations in which the Congress can rely on the Commerce Clause. And of course, this is not one of those three categories that the Supreme Court says Congress can do under the Commerce Clause. If Congress can do this, it can make people take all sorts of actions simply because they owned a product that once moved in interstate commerce, like bread or like soap, and they can face jail time if they do not do what Congress demands that they do. Even the individual mandate from Obamacare only established a penalty. It didn't put anybody in prison. I do not think that 90% of the Americans would support this universal background check if they had a chance to read the proposals. The motion to proceed also goes to a bill that contains language on straw purchasing and gun trafficking. I've voted to report this bill to the Senate floor. Many changes were made to that bill, and they were made at my suggestion. An amendment of mine was adopted. At the time, I still expressed concerns, even though I voted to bring the bill to the floor. And I spoke of my desires to have those concerns worked out before the bill would be brought up. I said that I would not necessarily support that bill that I voted for in committee on the floor out here if those concerns were not responded to, and they have not been addressed so far. And those provisions were tied to the ever-changing background check provisions. The whole process makes me wonder whether the effort to pass a bill on this subject really is a serious effort. It seems that if a half-baked bill is brought up, the majority can be sure that they can force Republicans not to agree to proceed to it. It seems like that may be just what they want to happen. If so, that is a very cynical way to treat a very serious issue. Madam President, how can we responsibly proceed to a bill that contains language that even its sponsor admits is not ready for consideration? I yield the floor and suggest the absence of a quorum.